Viewers, welcome to the Personal Injury Law Show. This is a show that talks about everything current in law of personal injuries and of importance to you, the viewer. My name's Tony Carbone. I'm a personal injury lawyer of 30 years experience. With me tonight I've got John Carancis, a partner in a law firm in workers' compensation. Good evening, John.
Hi Tony, hi viewers.
And also Alice Robinson, an associate in a law firm in insurance law. Good evening, Alice.
Good evening, Tony. Good evening, viewers.
Viewers, tonight, stay tuned. We've got Helen Versey. She's a tribunal member and we'll be talking about the Mental Health Tribunal and Mental Health Act and all the amendments.
However, before we get to that, Tony, what's in the news?
John, Alice, there's been a lot of stories, but what's really alarming is the increase in the number of significant injuries at work or deaths. In this one here, John, we've got Laurent's, which is a very popular cafe eatery.
Exactly.
And a fellow's lost his arm.
In December 2013, Tony, he's working in the factory of Laurent Bakery, and unfortunately his hand gets caught in an unguarded machine and is cut off.
Isn't it bizarre in this day and age, with all the changes to the Occupational Health and Safety Act and regulations, that this is still occurring?
It's pretty incredible, Tony. It seems to be an all or nothing situation in relation to these severe workplace injuries. We've spoken in previous episodes about workplace deaths, and it seems to be, rather than anything middle of the road, we've got a whole arm coming off in a popular bakery, and I must admit, Tony, this is the last place I expected something like this to happen.
And on top of that, Tony, there's a $60,000 fine for this breach on the employer.
Yeah, look,
it's not high, is it?
No, it doesn't sound like a lot, not for a company of this size. But the sad thing is, this young person, I'd imagine they're young,
yes,
has got a life of, a bit of misery there.
Tony, he's lost his arm. He's got a substantial common law damages claim, which is probably worth in excess of $1 million, Tony.
I saw one last week that lost his arm from another unguarded machine.
Exactly.
It's sad that with all these changes, and I mean, the Work Cover Authority have made a song and dance about safety, so I'm not sure why they're still happening like this. Anyway, we'll come back to these stories. There's a lady who's suing for compensation, and she was very fortunate that her surgeon was vigilant to work out that some surveillance footage that was sent to him was not her.
This is a really interesting case, Tony, and it's well known that in workers' compensation cases that the insurance company or the defendant will conduct surveillance to make sure that the workers are doing and saying what they say they can do. And this is really interesting, Tony, because it's actually the work cover doctor who's picked up that it's not the claimant in the footage. And he would normally be given that sort of footage to say, well, you're examining the patient, but here's the footage showing the patient doing something different. How do you reconcile those two events? But it's the work cover doctor who said, well, actually, that's not this person. And I really need the work cover authority or somebody to clarify exactly what's going on.
Worst case scenario, John, what would happen here?
Well, Tony, the work cover insurer haven't helped their cause by refusing to provide this surveillance material to the plaintiff's lawyers.
Well, they've got egg on their face, that's why they don't want to produce it.
Well, exactly. So luckily and fortunately, the work cover doctor has pointed out to the insurer, hello, it's the wrong person.
Well, I guess the worst case scenario for someone like her is that the lawyers could abandon her claim, believing that it was her in the video.
Well, exactly.
There's always that risk.
There's a bit of a risk there, that's right.
Oh, well, just a bit more vigilance on the part of WorkSafe, I guess.
Exactly.
All right, there's a massive legal fallout over these large banks providing financial services advice.
Yes, and it seems as though, Tony, a fair amount of compensation has been flagged by some of the big four banks in relation to this issue. And it's an interesting case because it's a case about what we lawyers would call pure economic loss. So it's about financial losses, or in this case, paying for a service where you're not getting 100% of what you've paid for.
Well, ANZ have agreed to pay $30 million to their 8,500 clients.
That's right.
So the allegation is, Tony, that customers are being charged for financial services which they never received.
Or advice that they've never received. Yeah. But I think it goes beyond that in some instances where they've been given very bad advice. You know, one example I heard of recently was someone asking a financial planner, I want my money to be capital guaranteed.
Yes.
He was told it was capital guaranteed and then he lost 20%.
Okay.
which is pretty tragic, really.
And then we've got the issue of secret commissions,
There's trailing commissions and there's
Yes.
things like that.
Which
so
are
that,
not-
that's also.
which are
Fees
not
and
being
so on.
disclosed to the customer.
I'll tell you what I found. There was an instance where I got some advice myself, and I think the person giving me advice didn't really know what they were trying to tell me, and so it didn't
Okay.
really give me much confidence in what they were, you know.
Well, I hope you didn't follow his advice, Tony.
No, look, you know what I'm like. But, the thing is, I wasn't confident in what I was being told, so I sort of steered clear of that one.
Yes,
But I mean,
think
the average
so.
consumer would probably listen.
Oh, and generally speaking,
Yeah.
when you're paying for a product, you can reasonably expect that you're getting what you pay for. And that's really at the centre of this whole dispute, I think.
So look, there might be a case of better educating the people giving the advice.
Yes, it
because I
could
mean,
well
there's
be.
a lot of rules and regulations around this already, isn't there?
Yes, it's very heavily regulated industry, Tony, and it could just be that the training's not quite up to scratch and it's not translating across the table, as it were.
Exactly. John, back to you again. A man is in a serious condition following a bobcat accident
Yes.
in Paran.
Yes, it's he's driving along, and he gets basically jammed, and his leg is trapped. And Tony, it's just another example of, you know, workers and employers need to be aware of the workplace, and that safety is paramount, Tony.
Yep. And this is a case where he's got his leg trapped, serious injury.
Yes, well, it sounds like it on its face, doesn't it, Tony?
And as we all know, Tony, if this bobcat is registered, then it falls under the Transport Accident Scheme.
So there might be an overlap between the two different
Bit of a
compensation
crossover
schemes.
claim,
Exactly.
that's
Work cover
right.
and
That's
PAC.
right.
But look, it's sad once again, you know, serious injury again at work. You know, we're working too fast, or we're not being careful enough, or
Exactly.
maybe someone's flouting the rules.
Exactly.
Okay, this Grocon Waller collapsed and those 3 people died.
Yes, the in
still
Swanson Street.
still in the
Yes,
courts.
still in the courts, Tony. We know that Grocon pled guilty and they have paid a fine. However, the subcontractor that put up the signs, the boarding on the wall, is pleading not guilty on the basis that he was not able to obtain the permit. He had no right to. Now, we're
So what was
awaiting...
his role? Just to put up the sign?
Well, exactly, yes. So he's relying on the occupier telling him, no, you can do this. We're waiting on the court judgment there, Tony. It's a very interesting case.
I just think this is one of those situations where you've got a dispute between a builder and a subcontractor,
Yeah.
and I do find it interesting that the subcontractor's pled not guilty, as John mentioned, and I understand the motivation for doing so, especially if you're under the direction of the occupier. But I think we've only seen the very beginning of what will be some serious tension between these two parties in the future.
Viewers, we've got to go to the sponsors break. Thanks for coming on board, John.
Thanks, Tony.
After the break, viewers, we've got Helen Versey, and we'll be taking up this issue of the Mental Health Act. Viewers, welcome back to the show. Today we're talking about the Mental Health Act and the Tribunal, and we're fortunate to have Helen Versey, who's a lawyer, among many other things, Helen. You've got a list of accreditations as long as my arm, but we're happy to have you here. Welcome back.
Thank you, Tony.
Now-
Pleasure to be back.
Now, Helen, your role at the Tribunal, what do you do?
Well, I'm one of the legal members of the Mental Health Tribunal. The Tribunal always sits with a legal member, a psychiatric or medical member, and a community member. So we're a 3-person tribunal.
Now, what are the objectives of the Act?
So Victoria has, Tony, a new Mental Health Act which was brought in as of last year, and the Act has a broad range of objectives surrounding patient care in mental health, but it's probably best to say that the Act is focused upon providing for the administration of the least restrictive treatment for the best therapeutic outcome. And so the idea is that we are treating our mental health patients without forming an emphasis on involuntary treatment unless it's absolutely necessary, while still achieving the best health outcome that we can in the circumstances. So it's trying to achieve a fairly complex purpose, Tony.
Helen, what are the factors that you look at before you place a person under compulsory treatment order?
Well, you would look at, the Act requires you to, first of all, decide they've got a mental illness.
Well, that would be a doctor giving you that diagnosis.
Yes, but you still have to look at the evidence and be satisfied that the person is suffering from mental illness as defined under the Act.
Yes.
And then that the mental illness requires immediate treatment, and that without that treatment they would either have serious deterioration in their mental health, or it would cause serious harm to themselves or others, that they can get that treatment under a treatment order and they can't be treated in a less restrictive way. In other words, they can't be treated as a voluntary patient. And of course, there are two different forms of an involuntary treatment order. One is a community treatment order whereby the person can be treated in the community, and we're required to make a community treatment order unless they have to be treated as an inpatient in a hospital.
Well, Alice, it sounds to me that the preference, for want of a better word, is that people are voluntarily treated for
That's
their
right.
mental health issues as opposed to compulsory.
That's right, and Tony, the Act does place a fairly important emphasis on voluntary treatment, or that is treatment that's not forced upon a mental health patient. These people are already in a fairly vulnerable position because of the illnesses they're suffering, and I think the Act is really trying to achieve the best treatment without having it be a restrictive sort of situation in that regard, and that's why the tribunal are obliged to first of all administer those community treatment orders unless there's absolutely no other option.
And I think the other thing to remember as well is that mental illness is the only form of illness where people are actually forced to have treatment against their will. You know, you can have cancer and you can choose to die of that cancer and not have any treatment at all. So
That's right.
I think that's why it's so important that as far as you can, people should be allowed to choose their treatment and be treated voluntarily.
Alice, do you think the reason why people with mental illnesses are treated differently is because society's scared of them? Society's got an inherent fear that someone that's considered to have mental health issues could harm someone else.
I think that
There's
there's
an element of
a
that.
variety of factors. I think it'd be silly to say that doesn't play some sort of part, but I think also you're talking about patients who are particularly vulnerable because of their mental health issues, and as Helen has just mentioned, the mental health space is almost diametrically opposed to the physical health, in the sense that you can't ever command physical treatment, but you can refuse it if you choose to do so, whereas in the mental health area it's more about whether we're imposing treatment upon people because they need it and they're not aware of that need, or they need it and because they pose a risk to themselves or others, and so it is a very complex area in that
touchy
regard.
area.
Yeah.
Helen, if someone is in your tribunal and they're there involuntarily, and the family members, loved ones, guardians and that are in there saying, please make an order for treatment, whose views would you... I know you've got to balance it all up, but do you generally listen to the family members
Absolutely. And in
ahead
fact,
of the patient, or...
No.
No?
Again, it's a very fine balance, and everything depends on the particular facts of each case. The patient's views are taken into account as far as possible. The tribunal is obliged to also take into account family members and carers. So the Act is intended to include everyone in the decision-making process, really. So we always welcome family members and carers. We're really pleased if they attend. And of course we will listen to them, because often they're the person that have known the person longest. They almost certainly have known them much longer than the treating team. And their input is invaluable. So it's a question of balance, but really the Act requires that you, as far as you can, and that depends on the wellness or otherwise of the patient, you take into account their views and what they want from treatment. And, you know, the treating team as well is supposed to negotiate and take into account their own views, even if they're an involuntary patient.
Alice, do you know what electroconvulsive treatment is?
Yes, so electroconvulsive treatment is where the mental health or the patient, I should say, is subjected or where electroconvulsive therapy is used on the patient to sort of help reset them, I suppose, in layman's terms. And usually the patient's given a relaxant drug before the shocks are administered in the appropriate sort of dosage, and that is sort of designed to help with their mental equilibrium.
And is that a last resort, Helen?
Not necessarily, but I should add actually they're always anaesthetised. They have a general anaesthetic before it's applied, and it's generally recognised by almost every psychiatrist I've spoken to as something that can, if someone's very ill, especially say with depression, you know, suicidal, or very resistant to other forms of treatment, that it can very quickly reset things and get people on the road to recovery quickly. It is one of the changes in the Mental Health Act is that if a patient doesn't have capacity to consent to electroconvulsive therapy, then they must be brought before the tribunal. The treating team can't make that decision themselves. It has to be a decision of the tribunal. And that's new, that before the treating team could make that decision.
Helen, hold that thought. We've got to go to a sponsors break. After the break, we'll take up this issue of electroconvulsive treatment. Viewers, welcome back to the show. Before the break, we were discussing this issue about electroconvulsive treatment, which is pretty invasive and drastic, isn't it, Helen?
You could say that,
yes.
but, you know, I mean, there's two schools of thought. Some might say that injecting people with drugs that they don't want to take is also drastic and invasive. I think one of the problems with ECT is that no one is quite sure how it works, and so it's very difficult to explain to people. But, you know, antipsychotic drugs have side effects. ECT, while there is, it can cause short-term memory loss.
I was going to say, what does it do to your brain?
Well, certainly everyone acknowledges that it can cause some short-term memory loss, but much more rarely it would cause longer-term memory loss. But, you know, there's all sorts of side effects from antipsychotic drugs, so it all balances out. But the one thing that certainly, I mean, I'm not a doctor, I'm a lawyer, but the one thing all the doctors that I've spoken to who've been involved with the administration of ECT say that it's a very effective way of treating someone who is not responding to other forms of treatment. And in fact, when the tribunal is deciding whether to make an order for the administration of ECT, apart from having to be satisfied that the patient themselves cannot give informed consent, they have to be satisfied it's the least restrictive form of treatment. And when you decide that, you would take into account how resistant they are to other forms of treatment.
I guess, Alice, if a family member or a loved one or someone that you know well was in a situation where they were considering or talking about suicidal ideation, you'd be pretty keen to get them to do whatever it takes, I guess.
I think that's probably right, Tony, and I think that when we're confronted with those kinds of thoughts and feelings, whether it's our own or those of somebody we're close to, our first instinct is to get them help, however that might help, might take shape. And I think that one of the biggest difficulties for mental health is that a lot of the help we are really kind of handing on to the patient without asking the patient how they feel about it, because all we can think about is, well, they'll be better off if we do this particular, or we have this particular intervention. When we talk a lot about our friends and having interventions when we don't like what our friends are doing, it's not so far removed, I suppose, in concept.
Let's get on to some cases. We'll get on to this interesting case of Hunter in New England Local Health District and McKenna, 2014 High Court decision. Alice, in brief, give us the facts of this case.
Yes, Tony, this is a very recent High Court decision involving a very unfortunate set of facts. Mr. Pettygrove was a mental health patient and he normally resided in Echuca. And he and a friend, Mr. Rose, had decided to take a bit of a holiday up into New South Wales. And whilst on holiday, Mr. Rose became concerned about Mr. Pettygrove's mental health to the point where he contacted a hospital in Taree saying that I think my friend needs some help, and took him to that hospital for treatment. Mr. Pettygrove was admitted to the hospital and the doctor made a few notes, including the fact that he had suicidal ideation, wanted to kill himself. The doctor was concerned he might be a harm, if not to himself, then possibly to others, and that he had a form of psychotic depression. In any event, he was kept for a little while in hospital. He was treated accordingly, and they got to the point where they decided he had equalised or stabilised a bit, and they decided to discharge him to the care of his friend to be taken back to Echuca to continue some treatment back there.
Mr. Pettygrove then strangled his friend to death, and that was the end of Mr. Rose. Now, Helen, this went to court. The family members of Mr. Rose sued the doctor and the hospital in question, saying that they should never have allowed him back into his care in circumstances where he was a risk to himself and others. What happened in the first instance, Helen?
Well, in the first instance, the
district court
did not uphold the claim. They found for the defendants, the doctor and the health authority. They weren't uncritical of the doctor, I should say, but what they found was that it wasn't a foreseeable risk. And the evidence was Mr. Pettigrew, he'd been a mental health patient for some 20 years. The hospital had contacted Echuca where he'd been treated and got all his medical records. And while there was certainly criticism of the doctor that he perhaps failed to properly examine him and had allowed this to happen, as I understand it, Mr. Rose was willing, and of course, bear in mind, he was a friend of this man's and he travelled to New South Wales with him. I think the hospital, from memory, had also spoken to Mr. Pettigrew's mother, so everyone was anxious to get him back to Echuca where he'd been treated in the past. And there wasn't a history of him having homicidal thoughts. I mean, he according to the cases, he killed Mr. Rose in the belief he was having a psychotic episode, and it was in the belief that Mr. Rose had killed him in a past life.
What's alarming for me, Helen, is the fact that when they said they're going to go drive back to Echuca, they reduced the amount of medication he was taking because he was going to share the driving with him.
Actually, I don't think that they were aware he was going to share the driving. That actually happened, but I didn't think the hospital was aware of that.
What did they reduce his medication?
Well, they had given him medication, but I think one of the problems was that while they'd given him some risperidone, it wasn't probably quite enough to get him through the journey. And they'd in fact given him, Mr. Rose, they'd suggested a route whereby he could pop into psychiatric hospitals on the way home if he needed a top-up of medication. But I don't think it was that they'd actually reduced it, it was just that he didn't have enough to get him home.
This went on appeal. The Court of Appeal found in favour of the family of Mr. Rose.
Yep.
They awarded $251,723 went to the High Court and the High Court found against the family. Alice.
So, Tony, in short, the High Court overturned the decision of the Supreme Court of Appeal, finding that the Mental Health Act in New South Wales emphasises the independence of a patient, and therefore the hospital's decision to look after Mr Pettygrove's independence and discharge him to the care of his friend was in line with the Act, and therefore the court couldn't find them accountable for following the legislation.
And in fact, it went a bit further than that, because what it said was that the hospital, in the circumstances, was actually obliged under the New South Wales Mental Health Act to release him, because they couldn't detain him once there was a least restrictive option open to them, and that was to release him to the care of Mr Rose and let him go home. So once they'd formed that view, they weren't able to detain him.
Helen, thanks for coming on board.
Pleasure.
Alice, always a pleasure.
Thank you,
Viewers,
Tony.
thanks for watching. Stay tuned for future episodes. Go to our YouTube for past episodes. Go to our social media sites, Twitter and Facebook. And always remember to stay safe.